Well,
I'm going to turn this over to Joe.
thanks, Ann. I'm going to introduce our speaker today, Dr. Ben Borson. Ben has his own firm, the Borson Law Group. Ben got his JD at USF and his PhD at UC SF. Ben is primarily a patent prosecutor, but he's also done all types of IP agreement work, trademark work. Um, Today he's going to be talking to us about the recent case law in subject matter eligibility, written description, and obviousness double patenting. And we'll let Ben get started. Thanks, Ben, for doing this for us.
All right, thank you very much, Joe and Ann. It's a pleasure to be back. It's a pleasure to be. How's that? I know that you said you'd rather have the questions through the chat or the Q&A, and I don't think Ann mentioned was intending to say QAnon, so let's not send them in through QAnon. Okay, so to get started, one other issue, because there is some intermittent construction out on the street outside my office, we will not only review Section 101 for patent eligibility, but also Construction Law 101. All right, this is the usual disclaimers. This information is presented for educational purposes and should not be relied upon as legal advice. If you have a legal question, please consult a competent attorney. Okay, subject matter eligibility. I'd like to, first of all, talk about a couple of cases involving life sciences. This is what I call a diagnostic on-ramp to Highway 101. And those of us in California know what 101 is. It's at least the highway. There are two patents subject in these decisions. The invention was CardioNet obtained two patents directed toward differential diagnosis of atrial fibrillation and atrial flutter. The background is that electrical activity leading to a heartbeat in a normal condition is initiated by depolarization of a group of cardiac cells called pacemakers in the sinoatrial or SA node. Electrical depolarization is conducted to another group of cells, the atrioventricular node or AV node. The AV node transmits electrical signals simultaneously to the ventricular muscle, causing the ventricles to contract in a coordinated fashion. So the issue here is that atrial fibrillation and atrial flutter are characterized by increased rates of depolarization in the atrioventricular node and atrial muscle, thereby producing rapid contractions of the atria. That's called atrial flutter. In atrial fibrillation, the rates of depolarization are increased further, and the atria do not contract in a coordinated fashion. Both of those are neither of those are particularly life-threatening, but they are debilitating. So if the AV nodes do not properly transmit signals, a ventricular pacemaker may take over. And if that pacemaker is not part of the regular ventricular conductors, the ventricles may not contract in a coordinated fashion, leading to ventricular fibrillation, a potentially fatal condition. So in CardioNet 1, the district court found the claims of U.S. patent number, and I'll just abbreviate 207, to be ineligible under 35 U.S.C. 101, drawn to a natural phenomenon. On appeal to the Federal Circuit, Judge Stoll noted that the claims included detecting atrial fibrillation and atrial flutter using nonlinear statistical approaches. This is relevant because one of the rejections was because it was related to the steps of the claim were things that could be done through the human mind. And using a nonlinear approach sort of takes it out of that mental category. In Alice Step 1, they look to see whether the claims focus on a specific means or method that improves a relevant technology. And so he just concluded that the claims of the 207 patent are directed to patent-eligible subject matter. Explaining the device more accurately detects the occurrence of atrial fibrillation and atrial flutter as distinct from ventricular tachycardia or other arrhythmias and allows for more reliable and immediate treatment of the two medical conditions. Generalizing the asserted claims as being directed to collecting, analyzing, and reporting data is inconsistent with our instruction to be careful to avoid oversimplifying the claims by looking at them generally and failing to account for the specific requirements of the claims. Now, in contrast to the 207 patent, the 850 patent is shown here. There's a representative claim 31, a system for reporting information related to arrhythmia events comprising a monitoring system configured to process and report physiological data and configured to identify arrhythmia events from physiological data. A monitoring station and a processing system configured to receive arrhythmia information from the monitoring system and configured to receive human-assisted arrhythmia information from the monitoring station. Importantly, this claim does not include a recitation of the nonlinear approach. So here Judge Lurie found at step 1, we conclude the claims are directed to collecting, analyzing, and displaying data, being abstract concepts and not eligible for patenting. So in summary, CardioNet 1, the claims were held eligible because of the use of nonlinear processes, whereas in CardioNet 2, no such limitations were present. Now, unfortunately, the specification of both these cases did not specifically claim which nonlinear processors were used. You know, there was no Bayesian analysis, there was no, K likelihood, there was no logistic regression or other such linear methods. So I think this could represent a possible challenge under 112 for lack of written description. All right, another case is another on-ramp to 101. This is Illumina versus Ariosa. And if you remember a few years ago in the Ariosa decision, the Federal Circuit held that the detection of cell-free fetal DNA in the mother's blood to detect fetal abnormalities was unpatentable. It was simply a law of nature. So this is the 540 patent that you may be familiar with. The diagnosis of, prior to that patent, the diagnosis of fetal genomic abnormalities required amniocentesis, which is a potentially harmful process, certainly for the baby and also possibly for the mother. So in Aria versus Sequinon, this is the prior case, the Federal Circuit held the claims to cell-free fetal DNA of the 540 patent to be ineligible as a law of nature. So here in this case, in Illumina, it took a different approach to claiming the cell-free DNA of the invalidated 540 patent. So according to the application, analysis of cell-free fetal DNA was uncertain because of the relatively small amount of fetal DNA in the maternal blood. So the approach was to, it's illustrated as Claim 1, a method comprising extracting DNA comprising maternal and fetal DNA fragments from a substantially cell-free sample of blood or plasma or blood serum of a pregnant female, and then producing a fraction of DNA extracted by size discrimination of the extracellular cell-free circulatory fetal and maternal DNA fragments, and then selectively removing the DNA fragments of greater than about 300 base pairs. And then, as Ariosa used to do, analyzing the DNA fragments in the fraction to produce a result of whether there's a genetic abnormality in the fetus. So Judge Lurie noted that laws of nature and natural phenomena are not patentable, but applications and uses of such laws and phenomena may be patentable. A claim to otherwise statutory subject matter does not become ineligible by its use of a law of nature or natural phenomenon, citing Diamond v. Deere. According to the Mayo-Alice test, we examined whether the claims are, quote, directed to, quote, unquote, a law of nature or natural phenomenon. Importantly, simply because a claim recites a judicial exception, that does not mean the claim is directed to the exception. That's an important point, that we'll often receive office actions from examiners that say that we recite a judicial, or we recite a natural phenomenon or a law of nature, and therefore it's directed to. And the answer is no, it's not. You have an argument here with the Illumina case that the Federal Circuit says no, directed to is not equivalent to recites. So going on further, the court said this is not a diagnostic case and it's not a method of treatment case. It is a method of preparation case. Those process steps change the composition of the mixture, resulting in a DNA fraction that is different from the naturally occurring fraction in the mother's blood. The focus of the dispute in this case is whether the claims of the 571 or 751 patent are, quote, directed to the natural phenomenon, i.e. whether they claim the discovered phenomenon itself versus eligible subject matter that exploits the discovery of the natural phenomenon. We conclude that the claims are not directed to the natural phenomenon, but rather to a patent-eligible method that utilizes it. Okay, there was, in October 2019, there was an update on USPTO guidance for Section 101. And I just have included this because some examiners apparently are not hip to this, but mere recitation of the judicial exception does not mean that the claim is directed to that judicial exception under Step 2A, Prong 2. Instead, under Prong 2, a claim that recites a judicial exception is not directed to that judicial exception if the claim as a whole integrates the recited judicial exception into a practical application of that exception. So patent examiners may consider claims ineligible if they simply recite the natural phenomenon. Illumina and the updated guidance may provide an argument that the claims are not directed to and therefore are patent eligible. So in Athena versus Mayo, this is a different case. Athena is the licensee of the 820 patent, which claims a methods for diagnosing neurological disorders by detecting antibodies to muscle-specific tyrosine kinase, or MuSK. A truncated version of 9 is presented. A method for diagnosing neurotransmission or developmental disorders in a mammal comprising detecting in the bodily fluid autoantibodies to an epitope of MuSK. So this is a method of diagnosis case. The district court noted that the 820's patent specification included specific concrete steps that were characterized as generally as routine conventional steps involving well-known enzyme-linked immunosorbent assay, or ELISA. The district court granted Mayo's motion holding the claims 6 to 9 were ineligible for reciting well-known and conventional steps, and the Federal Circuit affirmed. Now, enter Judge Newman. She said in dissent that claims 7 to 9 require specific steps. The panel majority ignores these steps and instead holds that claims 7 to 9 are directed to a natural law because the claimed advance was only the discovery of the natural law and that the additional steps recited apply only conventional techniques. She went on, eligibility is determined for the claim, including all its elements and limitations. Claim limitations cannot be discarded in determining patent eligibility. It is inappropriate to dissect the claims into old and new elements and then ignore the presence of the old elements in the analysis. Again, citing one of my favorite Supreme Court cases, Diamond v. Deere. Those inventors are not claiming a newly described autoantibody, but a new multi-step diagnostic method, a man-made reaction sequence employing new components in a new combination. Section 101 does not exclude new methods of diagnosis of human ailments. I think the Supreme Court has missed it. I'll get into that later. The majority misconstrues the claim, holding that claims 7 to 9 are directed to the concept of the correlation between the presence of MuSK autoantibodies and MuSK-related neurological diseases like myasthenia gravis, or MG. The claim method determines whether this correlation is present for diagnostic purposes, but the concept itself is not claimed. Diagnosing myasthenia gravis is not a law of nature, but a man-made chemical biomedical procedure. Section 101 does not turn on whether any claim steps are standard techniques. The appropriate analysis of the role of conventional processes in claims to new method is under Sections 102 and 103, not Section 101. Suggestions for drafting and arguing. Never state that any methods are standard or well known. I know that a lot of inventors in the academic world like to say, our methods are derived from well-known methods in the arts, such as ELISA. Instead of doing that, describe all methods in detail, and importantly, include methods of treatment steps like in Vanda versus Westward. Keep a continuing patent on file, if possible, and during process include court decisions and not only USPTO guidance. I think that's important so that you can give the examiner a sense of what he or she may be up against on appeal. So these next three cases are all about American Axle versus NEPCO, and I've titled this Section 101 has reached Detroit. That's actually a quote from one of the papers that American Axle filed in its cert petition, and we'll get to that later. So there are three cases, AAM1, that's the original Federal Circuit decision. Number 2 is 31 July 2020, and number 3 is 23 October. So the background relates to drive shafts for cars and trucks. They're called prop shafts in the art, are integral to nearly all vehicles. Prop shafts are generally hollow tubes and can suffer from vibrations, which can produce noise and damage the prop shaft and reduce their lifespan. There are three types of vibration: bending mode, shell mode, and torsion mode. Bending mode vibration involves energy transmitted longitudinally along the shaft and causes the shaft to bend. Shell mode vibration involves a standing wave transmitted circumferentially around the shaft and causes the cross-section of the shaft to deflect or bend. Now those two are types of vibration are relevant to claims 1, 22, and 36. Now torsion mode is a different vibration. It involves energy transmitted tangentially through the shaft and causes the shaft to twist. This was present in only claim 36. So American Axle, or AAM, addressed the problems by inserting liners into the hollow prop shafts, which dampened the vibrations and resulted in quieter, more long-lasting vehicles, and it was granted the 911 patent. 3 independent claims and several dependent claims issued. The district court decided sua sponde to consider only 2 of the independent claims, 1 and 22. And a truncated version of claim 22 is a method for manufacturing a shaft assembly of a driveline system comprising providing a hollow shaft member, drive shaft, tuning a mass and stiffness of at least one liner, and inserting the liner into the shaft member. Wherein the liner is tuned is a resistive absorber for attenuating shell mode vibrations and a tuned reactive absorber for attenuating bending mode vibrations. AAM sued NEPCO, thinking that was a great idea. NEPCO filed a motion for summary judgment, alleging that the claims were ineligible laws of nature, namely Hooke's law, which recites that the force exerted by a spring is equal to the spring constant times the x, or the displaced distance. If you remember Slinky days, F equals kx is quite relevant. And here this is a simple linear relationship, and the district court held for NEPCO, granting summary judgment. And they explained that neither the claims nor the spec describe how to achieve such tuning. The spec does not discuss the processes by which that liner is tuned. And the district court concluded the asserted claims as a whole are directed to laws of nature, Hooke's law, and frictional damping. The district court held the claims direction to tuning a liner to attenuate the different vibration modes amounted to merely, quote, instructing, close quote, one to apply Hooke's law without, quote, providing a particular means of how to craft a liner and prop shaft in order to do so. And so Judge Dyke for the Federal Circuit affirmed. So the asserted claims as a whole are directed to laws of nature, Hooke's law and frictional damping. However, the majority offered several other, quote, natural laws. One of them was Hooke's law with frictional damping. Another is Hooke's law with possibly other natural laws, and then Hooke's law and nothing more. In essence, AAM's argument is that the system of the invention, a driveline prop shaft and its liner, is too complex to be described by the mere application of Hooke's law, which itself is a simple linear approximation of a single degree of freedom spring mass system. Now that's Judge Dyke's language. So he admits that it's only a single degree of freedom spring mass system. The assertion that the system involved in the 911 patent is more complex than just the bare application of Hooke's law does not render the subject matter eligible. What's missing is any physical structure or steps for achieving the claimed result of damping 2 different types of vibrations. So they upheld the summary judgment of invalidity. Striking dissent from Judge Moore, the majority parrots the Alice Mayo 2-part test but reduces it to a single inquiry. If the claims are directed to a law of nature, even if the court cannot articulate the precise law of nature, then the claims are ineligible and all evidence of non-conventionality will be disregarded or just plain ignored. Pretty strong words from Judge Moore. Section 101 is monstrous enough. You need not even identify the precise natural law. The claims are, quote, directed to some unarticulated number of possibly natural laws, apparently smushed together and thus ineligible under Section 101. Further, the conclusion that claims 1 and 22 are representative is not correct. The parties did not agree and the courts did not hear arguments of limitations of the dependent claims. It's inappropriate in light of these facts for the majority to sua sponte declare the claims representative and ignore the expressly argued dependent claims and limitations and ignore Claim 36. The majority concludes that the inventive concepts make no difference. Section 101 should not subsume Section 112. The majority worries about result-oriented claiming. I'm worried about result-oriented judicial action. A request for a hearing en banc was denied 6-6. The court held Claim 22 to be ineligible under the invalidated Claim 8 of O'Reilly versus Morse, and several dissents were lodged, but only a few points are mentioned here. It's a very long series of dissents in this particular version. This is AAM2. The majority announces that a claim is patent ineligible if it clearly invokes a natural law and nothing more to accomplish a desired result, the so-called nothing more test. This case does not represent an application of O'Reilly. It's an expansion of that which would likely render ineligible claims found patent eligible by the O'Reilly court itself. Despite this, the majority forges on adopting a test that was proposed by no one. So the latest version is a petition for certiorari filed 28 December. And according to AAM, American Axle invented a new process for making a new and useful and tangible thing. It's the type of invention that's long been held eligible for patenting under Diamond v. Deere. Truncated questions presented. Number one, what was the appropriate standard for determining whether a patent is, quote, directed to, close quote, a patent ineligible concept under Step 1 of Mayo-Ellis? 2, is patent eligibility a question of law for the court based on the scope of the claims or a question of fact for the jury? My own view is that those are very good questions. Amici filed briefs at this early stage. Most agree with AAM the Supreme Court should grant certiorari. Among the Amici were New York Intellectual Property Law Association, or the NYIPLA, the Director of the USPTO, and the U.S. Solicitor General. According to the New York IPLA, the statute is clear and does not include any judicial exceptions. There are no other statutory obligations in Section 101 beyond utility. So Section 101 is based on the U.S. Constitution, and the statute reflects constitutional language, including discoveries. The definition of the word discoveries in 1789, and still does mean to uncover or to reveal. The Supreme Court has not overturned Section 101, but declared its own judicial exceptions as part of 101 and not considering 112. So a little bit more digging. Hooke's law is an approximation of a linear relationship F equals Kx. However, hollow tubes being rotated are not approximated by Hooke's law. Rather, the torsional stiffness of a shaft Kt is defined by a higher order, namely fourth power relationship. Kt equals pren pi times the modulus of elasticity g times a factor the outer diameter to the fourth power minus the inner diameter to the fourth power, all divided by 32 times the length in inches. And the courts did not address this issue, and it was not briefed according to what I read, and they did not look at Claim 36. Oh, by the way, Claim 36 did deal with all three of these vibration modes. Bending mode, including torsion mode vibrations. So it was an opportunity that was lost. Okay, a little bit on the lighter side. Stanford University Stanford filed application 925 directed to methods and computing systems for determining haplotype phase, an indication of the identity of the parent from whom a gene has been inherited. Here is a truncated version of Claim 1. A method for resolving haplotype phase comprising receiving and storing allele data, receiving and storing pedigree data, determining an inheritance state, receiving transition probability, receiving population linkage disequilibrium, determining haplotype phase, storing the haplotype phase on a computer system, and then displaying the stored haplotype phase using a computer. So all these are computer implemented steps, and the PTAB found that all steps of Claim 1 were directed to either mental steps or to mathematical concepts and were patent ineligible. The human mind could process the information, and the mathematical models per se are abstract ideas. All of the algorithms and computer systems or computer methods were well known, routine, and conventional. The PTAB held that the dependent claims recited, quote, providing a drug for treatment. They were too general to provide the needed inventive concept, and the Federal Circuit affirmed. So a little summary of 101. Section 101 is enmeshed with other statutory provisions. I think Section 112 is highly appropriate, certainly given the the varying degree, the varying opinions of majority and dissent. Avoid general language for computers and recite special purpose computers, see Bilski. Avoid functional claiming. Section 112 is a trap if claims are intended to be very broad. Do not state that any methods are well known. Describe them in detail. Rejections under Section 101 now includes claims similar to those of Diamond v. Deere, and AIM versus NEPCO is an example of that. Perhaps one reason for the holding in AIM is that in Deere, the computer acted to perform one of the manufacturing steps, namely opening the mold. Recite case law, not only the MPP, in preparation for appeal. Again, that's to give the examiner a sense of what he or she may be up against if there is an appeal brief filed. And then avoid the file first, invent later concept. That used to be prevalent, certainly for filing provisional applications. File on the concept and then follow it up with a more detailed description that actually puts meat on the claim's bones. Okay, future of 101. The National Security Commission on Artificial Intelligence, or NSCAI, created in 2019, has submitted a report to the President and Congress urging legislative reform. The judicial undermining of patent eligibility in defiance of the clear language of Section 101 of the Patent Act poses a clear and present danger to the pace of American innovation. They cite two national security interests tied to technology advancement. And then according to Adam Mossoff, the Supreme Court is now closing the patent system to the innovations it's long recognized as worthy of securing with patent protection. This has had a tremendously negative impact on the inventors and companies working in innovation industries that invest millions of dollars in creating new products and services that drive economic growth, job creation, and higher standards of living. The Supreme Court is undermining America's long-standing comparative advantage among world economies in securing reliable and effective patent rights for all inventors. Specifically, they recommend the Secretary of Commerce should assess and articulate the impact of the current patent eligibility laws on innovation and artificial intelligence and emerging technologies from the economic, trade, and national security policy perspective to better inform the legislative and agency efforts on patent eligibility reform. America's IP regime has spurred American ingenuity since the late 18th century by protecting, quote, any new and useful process, machine, manufacture, or composition of matter, close quote, that's Section 101, through staple legal institutions governed by the rule of law. Inventors and investors have relied on the America's IP system to provide the certainty necessary to justify large and risky R&D investments, which are critical. A strong and robust patent system is equally crucial to incentivizing American innovation in artificial intelligence and emerging technologies that affect national security. Unfortunately, recent patent eligibility court rulings have narrowed the scope of inventions that are eligible for patent protection. This has resulted in a broad swath of innovation that is now ineligible for patent protection in both digital technologies and biopharma, among others. Now, the report itself is quite lengthy. You can look it up yourself. I think it makes a strong case. Now, before we go on to Section 112, I just intersperse a few personal comments. Since I first started looking at 101 and the Supreme Court decisions, particularly in Mayo and Alice and others, I note that the Supreme Court has effectively denied patent protection for any discovery. I find that striking in that the word discovery appears in the Constitution, Article 1, Clause 8, Section 8, or Section 8, Clause 8, and that's reflected in the current statute of Section 101. So why the Supreme Court has, A, not overturned Section 101 and simply declared of its own volition, its own judicial philosophy that they just don't like it. So they're just not going to do it. All right, so certainly given the fact that the word discovery in 1789 and today means to reveal or uncover, it does not mean to create something brand new that's never been on the face of the earth. Okay, at this point, does anybody have any questions about Section 101 before we go to Section 112?
There was one comment, and I think it was the slide before the summary that you gave. The equation should have brackets. P-I asterisk G asterisk D-O, I don't know. The D-O.
That's the outer diameter to the fourth power minus the inner diameter to the fourth.
Yeah.
Yeah, I think that's right. Where it's bolded, D sub 0 to the fourth minus D sub I to the fourth. That should be in brackets. That was the comment.
Yeah, that's a good point, but I blame Wikipedia for this one. Because that's a direct copy and steal from Wikipedia about torsional stiffness.
So,
all right, well, thank you for that. I'll make a note and correct it.
Thank you, Mark.
Okay, there's some interesting recent cases on 112A, B, and F, including this wonderful phrase consisting essentially of, which many of us have used. The background is of these cases, this is NZP Med versus Actavis Labs, and it's actually Horizon Therapeutics that is the patentee here. These cases are related to methods and formulation for treating osteoarthritis. Claim 49 is illustrative. A topical formulation consisting essentially of 1 to 2% diclofenac sodium, 40 to 50% DMSO, 23 to 29% ethanol, 12 to 12, that's not correct, 12 to some other percentage of propylene glycol, and hydroxyl propyl cellulose and water to make up 100% weight per weight, wherein the topical formulation has a viscosity of 500 to 5,000 centipoise. So this is the preamble using consisting essentially of. The district court found this term consisting essentially of to be indefinite because the basic and novel properties of an invention are part of the construction of the claim containing the phrase consisting essentially of. The Nautilus standard applies. The Federal Circuit affirmed, reciting that the terms better drying time, higher viscosity, increased transdermal flux, greater pharmacokinetic absorption, and favorable stability were indefinite for failing to provide tests for those terms. Consisting essentially of permits inclusion of components not listed in the claim, provided that they do not materially affect the base and novel properties of the invention. That's really key to this. You can use comprising, in which you can include anything, whether it affects the basic or novel properties of the invention or not. So according to Judge Newman, again, the majority states having used the phrase consisting essentially of and thereby incorporating unlisted ingredients or steps that do not materially affect the basic and novel properties of the invention A drafter cannot later escape the definiteness requirement by arguing that the basic and novel properties of the invention are in the spec, not the claims. This statement is contrary to long-standing law and practices summarized in Nautilus. And here we're citing Conoco versus Energy and Environmental International. The court recognized the difference between consisting essentially of, and stating that while consisting of limits the claimed invention, it does not limit aspects unrelated to the invention. However, no precedent has held that consisting essentially of composition claims are invalid unless they include the properties of the composition in the claims. Be careful about using consisting essentially of. Use of this phrase could be the basis for a challenge. A better approach would be to use comprises because the question of non-enumerated components rendering the composition unfit for its intended purposes is less relevant. So, and see comments later on comprises ... consisting of. If an examiner suggests amending comprises to consisting essentially of or consists of, consider other alternatives. An expert declaration could address the matters of fact relating the roles of non-enumerated components. Another approach would be to include in the claims some of the methods by which characteristics of the non-enumerated components can be analyzed. So that's kind of like a Jepson claim. You could, consider having a preamble reflecting the prior art, and then you can have it characterize that, further elements would be added as in a Jepson claim. All right, this is Allergan versus Sandoz, and this relates to the term wherein. Is it limiting, inherent, or aspirational? I sort of started singing that song, Wherein the Money, so that's where that title came from. So patent claims are often drafted with claims that include the word wherein or whereby. Some examiners request such words to be removed. And a truncated version of the 435 patent, it's actually the 453 patent owned by Allergan, is referred as below. A method of treating a patient with glaucoma or ophthalmologic hypertension comprising administering two drugs, wherein the method is effective as the administration of 0.2% brimonidine tartrate monotherapy 3 times a day, and wherein the method reduces the incidence of one or more adverse events when compared to the administration of 0.2% weight per volume brimonidine tartrate monotherapy 3 times daily. So here is the use of wherein in 2 locations. The district court held that the wherein clauses were limiting because they were material to patentability and expressed the inventive concept of the claimed invention. Therefore, the district court held the claims not invalid. On appeal, Sandoz argued that, number 1, the wherein clauses merely state the intended results, and 2, the recited results are not, quote, material to patentability. Federal Circuit affirmed the district court decision. Example 1 formulation administered BID demonstrated a favorable safety profile that was comparable to timolol BID and better than brimonidine TID with regard the incidence of adverse events. Ensure that wherein clauses not merely reflect aspirational or inherent results or intended uses. Include prior art results in the claims. This is a Jepson-type claim. Comparing the results obtained by the inventors, thereby providing support and that the plain meaning of the wherein clause supports patentability. This is actually something that the Japanese Patent Office likes to see. They like to see a claim compared to the closest prior art. Inclusion of references to the spec and prosecution history can support a conclusion that wherein clauses are limiting and therefore are material to patentability and not indefinite. So comprising ... consisting of. This is Amgen versus Amneal. Amgen is the owner of the 405 patent. Claims are drawn to pharmaceutical compositions comprising a calcium receptor active compound and Markouche groups identifying enumerated excipients consisting of, enumerated binders selected from the group consisting of, and enumerated disintegrants selected from the group consisting of. Amgen sued Amneal for infringement, and Amneal argued that the inclusion of both comprises in the preamble and consisting of in the Markouche groups rendered the claims invalid as indefinite. So patent examiners have rejected such claims and may request that the word comprises in the preamble should be replaced by consisting of, in line with the presumption that Marcouche groups in the preamble should be closed to unrecited elements. In a Markman hearing, the district court held that Amgen did not overcome the, quote, very strong, close quote, presumption that Marcouche groups for binder and disintegrant elements are closed to unrecited binders and disintegrants. Amgen appealed the claim construction. Federal Circuit reversed. The comprising term in the preamble renders the claim open-ended even when other language restricts the scope of particularly claimed elements, and the consisting of term here only applies to the Marcouche groups. Without more, such language is satisfied when an accused product contains a component that is from the Marcouche group. It does not forbid infringement of the claim if an additional component is present functionally, similar to the component identified in the Marcouche group. Okay, moving to 112F, the current standard for analysis of 112F during examination is based on the Williamson versus Citrix case from 2015. And prior to Williamson, if a claim used the term, quote, means for, close quote, or step for, close quote, there's a strong presumption the claim should be analyzed under 112F. And B, if means for is not present, there was a strong presumption that the claim did not fall under 112F. Under Williamson, the presumption in B was discarded. If the claim contained so-called nonce words having no structural meaning, it would be limiting to the disclosure in the spec and their equivalents. Examples of nonce terms include module for, device for, unit for, component for, element for, member for, apparatus for, machine for, configure to, and system for. So we're all familiar with those ideas. There's a general term and then followed with a preposition. And historically, in the computer-implemented arts, inventions are often drafted in means plus function format, claiming results without reciting the steps needed. This was based on the idea that a very savvy computer programmer could draft code based on the desired results. Prior to Williamson, the courts applied the In re Packard standard. A claim would not be considered to fall under 112F if the claim were, quote, amenable to construction or not insolubly ambiguous. The Williamson standard has been incorporated into the 2019 guidance where the use of means for invokes 112F. Also, according to the 2019 guidance for computer-implemented inventions under 112F, the spec must disclose an algorithm or else the claim is indefinite. In the Aoyama case, the Federal Circuit stated, when the disclosed structure is a computer program to carry out an algorithm, the disclosed structure is a special purpose computer, as in Bilski. The applicant may express that algorithm in any understandable terms, including a mathematical formula, prose, or flowchart by any other manner that provides sufficient structure. In Lizard Tech, under 112A, the court found that a single example did not support a broad genus claim. And then a little bit later in Hynix, so long as the disclosure of a species is sufficient to convey one to skill in the art that the inventor possessed the subject matter of the genus will be supported by adequate written description. A little bit new guidance from this year, the USPTO recently issued new guidance on post-grant proceedings. Prior to the 2021 guidance, the PTAB used the Packard standard. A claim is indefinite if it contains words or phrases whose meaning is unclear. And the new guidance says the claim construction will now be the same as the Supreme Court decision in Nautilus, whereby a claim is unpatentable for indefiniteness if the claim read in light of the spec delineating the patent and prosecution history fails to inform with reasonable clarity those skilled in the art about the scope of the invention. According to PTO guidance, to overcome problems with 112F and specs, the claim should include an algorithm. Although the 2019 and 21 guidances favor the use of algorithm, there may be a conflict with Section 101. Under Section 101, one of the categories of patent ineligible subject matter for being abstract are mathematical concepts, mathematical relationships, formulations, mathematical calculations may all be abstract ideas and therefore not patent eligible. The courts have not reconciled this conflict. Now, in addition to nonce words, be careful about the use of prepositions, for, to, and the like. prepositions may lead to the finding that the claim is under 112F. And this is my own quote: a preposition is not something to end a sentence with. Although I think that was taken from Winston Churchill originally. Okay, lastly, obviousness-type double patenting. It's a common ground for rejection if the claims of one application are obvious variants of another application or patent having the same inventors. Overcoming such a rejection can be by filing a terminal disclaimer. The requirement for filing a terminal disclaimer is that both applications or patents be commonly owned. This is an interesting case in which that issue was not quite so clear-cut. In Immunex versus Sandoz, Immunex holds an exclusive license from Roche for the production of Enbrel comprising the chemical etanercept. The claims of the 182 and 225 patents are directed to methods of manufacture of etanercept. Sandoz applied for an abbreviated biologics license application, ABLA, which is an act of infringement like filing an ANDA under the Hatch-Waxman Act. The case turned on the meaning of the license and accord and satisfaction agreements between Roche and Immunex. Here the court decided, or reasoned, that Roche retained sufficient rights in the invention so the patents at issue were not commonly owned by Immunex. Roche retained the right to use the patented product for internal non-clinical research only and was obligated to assist Immunex in any infringement litigation and retained a secondary right to sue if Immunex failed to rectify the infringement. If such a right were triggered, Roche's right to sue may be determined by its under sole control. It may initiate suit and retaining the entirety of any damage. The court held that Roche had retained sufficient rights and Immunex was not the owner of both patents. Therefore, the terminal disclaimer was defective, not enforceable, and it resulted in invalidation of the patent. The 182 and 225 patents were both divisionals resulting from a restriction requirement. Generally, if a restriction requirement is made and the claims are distinct and terminal disclaimers are not required. However, when the interpretation of a license agreement controls the situation is less clear. Properly drafted license agreements should ensure that the substantive provisions are explicit, including what, if anything, is retained by the licensor. My view is that ideally any agreement should be an assignment of rights with possibly a license-back provision. So with that, I would invite any other questions or comments.
So Ben, this is Joe. I have one question with regard to the Illumina case. It seems as if we could make, if we could make the claims kind of drawn to a method of preparing in some fashion, even a diagnostic claim, you might have more legs
Absolutely.
than
I
just.
agree, Joe. Very good. I'm sorry. Go ahead. I didn't.
No. I was just saying that it may have a better chance of surviving than just like a straight. You could do it even with just a biomarker and a correlation, but just make it a method of preparing.
Well, I think that's a good idea, and for kit claims, a method of if you include a series of biomarkers in a kit claim, that's essentially what you're doing, is that you're applying a method of manufacturing or a method of preparing the kit components. And so that could sort of piggyback, and that's why I thought that case was interesting, because it's a departure from the original Ariosa decision. And I can disagree with the Ariosa decision based on discoveries, and what the Supreme Court has effectively removed the word discovery from the patent statute, which I think is an unfortunate state of affairs. And maybe this new push by the NSCI might have some legs. I think there are a number of senators and representatives that might find that if we're actually losing the innovation race, we had to do something. And why not start by returning to the original text of the statute? I mean, Congress could do that. They could simply pass a law reciting Section 101 as it was originally enacted in Section 1 in 1952. I mean, I think that would be a very simple solution. and then maybe explicitly in the markup state that discoveries in 1789 means the same as they do today. And if the drafters of the Constitution thought that discoveries should be patent eligible, why does the Supreme Court disagree?
Mm-hmm. So are there any other questions for Ben? You can send them via the Q&A or the chat, sorry.
Joe, before we break off, I know that you're going to send these slides out to the membership. That's fine. But would you mind if I provide a little corrected version with the brackets around the D0 and DI?
Sure. Yeah, that would be fine.
Yeah, I'll just do that and I'll email it to you directly.
Thank you very much.
Yeah, and Ben, you can send that to me when you have a chance.
Yeah, it'll be within 2 minutes. You know,
Oh,
that was an
okay.
oversight on my part. So there
Okay.
you have it.
No, that was a really good, thank you very much, Ben, for giving us an update on, those three statutes and the case law associated with them. It's been very instructive and given us some additional ammunition. Thank you very much. And with that, I'll close it up.